Larry, you put this case in here from the Fifth Circuit Court of Appeals from the state of Mississippi. It deals with restoration of voting rights. I'm hoping that you will finally admit that federal judges appointed by one party are different from those appointed by the other party. Do you think that you can finally do that this episode?
No, I don't think I can.
Stubborn as usual. Let me set this up just a tad. Mississippi has one of the strictest bans in the United States. Now, let me read their law. This is me reading from their text, not lawyer Andy. Just want to make that clear. And it's actually in their constitution. And it says, every inhabitant of this state except idiots, and does it say that?
It does.
Okay, now that's funny, Larry.
Wow.
Every inhabitant of this state, except for idiots and insane persons, who is a citizen of the United States of America, 18 years old and upward, who has been a resident of this state for 1 year, and for 1 year in the country in which he offers to vote, and for 6 months in the election precinct or in the incorporated city or town for which he offers to vote, and who is duly registered as provided in this article, and who has never been convicted of murder, rape, robbery, theft, arson, obtaining money or goods under false pretense, hold on, the list goes on, perjury, forgery, embezzlement, or bigamy, is declared to be a qualified elector, except that he shall be qualified to vote for president and vice president of the United States, if he meets the requirements established by Congress, therefore, and is otherwise a qualified elector.
Whoa.
So I think the idiots and insane persons, those are terms that were like readily used back in your youth, Larry, back in the 1800s when you were coming up. I think that was kind of like regular language.
Yes, this language dates back to their constitution, I think of 1890, somewhere in the 1890s. And I was getting up in my adulthood by then, but...
All right, well, this is some really broad and archaic language, to say the least. Idiots and insane persons are those convicted of PFR-type offenses are excluded. So what is your take on this outcome?
So just to clarify, one of the things you read, you said country and you meant county, 1 year in the county. But okay, it means that the state of Mississippi can continue denying people previously convicted of certain felonies the right to vote because of a new ruling from the Fifth Circuit Court of Appeals. On Thursday, the court's majority overturned a ruling issued by a lower court and the Fifth Circuit itself, a 3-judge panel, which held Mississippi's disenfranchisement law was unconstitutional because it inflicted, quote, cruel and unusual punishment. The Fifth Circuit Court of Appeals found that the disenfranchisement is not punishment imposed on people for life, but a regulatory function of the state to protect the public and a function that is entirely within its right to flex. The majority also said that disenfranchisement isn't up to snuff when it interprets the cruel and unusual punishment, noting that acts such as hanging, burning at the stake, and beheading, to name a few. Now, those are not unconstitutional or cruel and unusual. I remember I've often pontificated in stating that if capital punishment isn't cruel and unusual, it's difficult to imagine that anything else can be. And this is why I say that, because this is not cruel and unusual punishment. If you can do all those things, then it's not cruel and unusual. Telling a person that they'll have to sit out an election doesn't seem to be quite to the level of beheading, does it?
It seems to be less than beheading, yes.
Okay.
All right, well, this case was filed in 2018 by 6 Mississippi citizens who have been permanently disenfranchised. Among them, Dennis Hopkins, disenfranchised since 1998, was convicted of grand larceny. Herman Parker Jr., a public employee of the Vicksburg Housing Authority, is disenfranchised because of a grand larceny conviction when he was 19. Byron DeMond Coleman became disenfranchised in 97 because of a conviction for receiving stolen property. These plaintiffs have completed all terms of their sentences. They sued the Mississippi Secretary of State in his official capacity, challenging Sections 241 and 253 and requesting declaratory and injunctive relief for alleged violations of the First, 8th, and 14th Amendments to the United States Constitution. What specifically did they allege, Larry?
Well, they asserted that the Mississippi Constitution, Section 241, inflicts cruel and unusual punishment of permanent disenfranchisement while it violates the Equal Protection Clause by impermissibly burdening their right to vote.
Section 1 of the 14th Amendment guarantees due process and equal protection of the laws. U.S. Constitutional Amendment, I guess that's 14, IV, Section 1. After a long process of, exegesis, it is settled that the Due Process Clause incorporates much of the Bill of Rights, and state governments must respect protections like the Eighth Amendment's prohibition of cruel and unusual punishment. Section 2 of the 14th Amendment is less familiar but more specific. It reduces the number of representatives in Congress to which a state is entitled if that state disenfranchises any of its male, non-Indian citizens over the age of 21. But there is a single exception. States may not be penalized for disenfranchising a citizen for participation in rebellion or other crime. Has the Supreme Court previously affirmed lifetime bans?
Yes. The opinion references that in 1898, that seems a long time ago, the Supreme Court described felon disenfranchisement laws as a type of measure designed to protect the public and not punish for past offenses.
The dissenting opinion on the case comes from 6 liberal, pointy-headed judges, written by Judge James L. Dennis. They stated a lifetime voting ban is unconstitutional. Voting is the lifeblood of our democracy, and the deprivation of the right to vote saps citizens of the ability to have a say in how and by whom they are governed. Dennis wrote, permanent denial of the franchise, then, is an exceptionally severe penalty, constituting nothing short of the denial of the democratic core of American citizenship. Denying released offenders the right to vote takes away their full dignity as citizens, separates them from the rest of their community, and reduces them to other status. I respectfully dissent. And what do you say about that then, sir?
Oh, I agree with the dissent, but I also see the majority's logic. Judge Edith Jones wrote, go and convince state legislators. Do the hard work of persuading your fellow citizens that the law should be changed.
The original lawsuit was filed by the Southern Poverty Law Center, Simpson Thatcher, and Bartlett LLP, and others on behalf of state citizens who lost their voting rights. The Office of Attorney General Lynn Fitch opposed the lawsuit representing the state. What happens next?
Well, the court's majority stated it very succinctly. They said, if Mississippians want to remove disenfranchisement from the law, they will have to petition the Mississippi legislature to do so. Individuals can also ask lawmakers to file legislation to return their voting rights, but it must be approved by both the Senate and House and approved by the governor. Now, we don't want judges to legislate from the bench, do we, Andy?
At times, I think we do, Larry. When it is beneficial to what we want, yes, then I think so.
Well, wait. I'm getting lost here now. I have heard for my entire 200 plus years of adult life that we want judges who only interpret the law. They're not only interpreting Mississippi's law, they're interpreting Mississippi's Constitution and all that archaic language that's included in there, idiots and insane persons and whatever all you just read. Now, you don't want a federal judge that's appointed for life to come in and tell the good, hard-working people down in Mississippi that they can't write their own constitution and have their own. That seems like quite a stretch from not legislating from bench. That would seem just the opposite. That would be legislating from the bench completely to come in and undo that without going through the people of Mississippi.
I think, though, unless it's something we can't pass, suppose it's something that just will not pass through the legislature.
Well,
so then in a joint statement from several civil and voting rights advocacy groups, including the League of Women Voters for Mississippi, Mississippi Center for Justice, One Voice, Mississippi Votes, Mississippi State Conference for the NAACP, Black Voters Matter, and Mississippi Poor People's Campaign, they call the court's majority opinion a failure to democracy. Retaining this ban as part of Mississippi's constitutional is an affront to our democracy, the statement reads. We are disappointed to see the court allow the state to continue taking the right to vote away from Mississippians for life under a state constitutional provision that was specifically designed to disenfranchise black men, and that, to this day, disproportionately impacts black Mississippians. Larry, then didn't Florida reverse, it was their Fourth Amendment to their constitutional that banned felons from voting. So this is the same thing, essentially. And they got their constitution overturned, and the legislature came right back around, and I'll say it politely, they effed up their chances to vote.
They did, and that was initiated by the conservative lawmakers in Florida. But elections have consequences. We are allowed in a democratic society where we choose our destiny to impose bad laws on ourselves, as long as they don't break the Constitution. And the Constitution, under the conservative view, is interpreted very narrowly, that the states get to do this. This was a 13-6 decision on it when it was a panel of 3. I think it was a 2-1 panel decision, but then they filed for en banc, which is a full court review. And you can see that 13-6 is pretty lopsided. So that means there's a lot of people on the Fifth Circuit that don't believe there should be legislating from the bench, that this is a Mississippi decision. They don't see a constitutional infraction here, that not being able to vote for your rest of life is a constitutional right. So if you don't like that big an interpretation, then you've got to have different people appointed to federal judgeships and appellate courts. And what was appointed in the 4 previous years to this present term didn't help the courts of appeals at all in terms of broadening the interpretation. And what's going to be appointed after 2024, when we roll into 2025, depending on the outcome of the election, we're going to get more of these type of judges. So elections have consequences.
And Chance, I'm going to throw you on the spot. Which states does the Fifth Circuit cover? Obviously Mississippi.
No, I can't remember what all states are covered there, but I could tell you one thing that, from my point of view, this is a constitutional hemorrhage. And, I'm not so sure the legislature, at any time is going to be able to fully fix it. And, this kind of race-based disenfranchisement is just, it is a tragedy. And it just bothers me. So that statement, that joint statement, is very compelling, and I would tend to agree with it.
So it's going to be Mississippi, probably Louisiana,
Texas.
What's above that?
Texas is in it, the Fifth Circuit.
Oh, okay.
Yeah, let's just call it the South.
Yeah,
right. The central South-ish.
Yeah, it was. It would have also included Georgia at one time before they created the 11th Circuit. Yeah, Georgia was in the Fifth Circuit at one time.
Does that mean Florida was then too?
I do believe it was.
Okay. That would make sense.
They created the 11th Circuit when Jimmy Carter was president.
Oh, look at you, Mr. Historian.
So,
but politically, how do you make this happen? I don't know if Mississippi has a ballot initiative the way that Florida did, where they put it on there and the people voted to revoke, to let the people vote again. Could Mississippi do the similar thing?
Possibly, but there are people in Mississippi who don't want that to happen. See, Mississippi already has, I think, the highest percentage of black voters in the country. I think the population is about roughly 40% black. And that it puts you in jeopardy of having black rule in that state if all the black people are eligible to vote. So there's this paranoia that blacks vote in lockstep with the Democrat Party. Now, that's not a true thing. Trump is going to prove that in this election cycle that that's not the case. But that's what a lot of people fear, is that would lead to radical control of the state government of Mississippi. And they point their hand, they will raise their, they'll say, look what's going on in Jackson. Do you want the whole state? Because Jackson is a hugely majority black city, and Jackson has its share of urban problems. And they say, this is what you get with those kind of people running it. And it's a scare tactic. So it's not likely that the political process is going to be able to fix this. But if the judiciary was slightly more sympathetic to it, and if the case was built to show that it was racially motivated, you've got to prove that. You can't just do that with innuendo. You've got to come in and show And I don't know how you would do that, but you've got to show that this was clearly intended to keep tens of thousands of blacks from voting.
Probably millions.
Well, I'm talking about in Mississippi, it's not millions, but in Mississippi, there's more blacks disenfranchised than any other ethnic group.
You've been listening to FYP.